worth several billions of dollars per annum. Nevertheless, we wallow in poverty, misery, and darkness. Under colonialism, every mineral found under our soil and waters belonged to the colonizers. The monarch in the metropolis gave European companies license to mine our minerals, and the profits belonged to the foreign companies and the crown. After all, we were colonial subjects. Indeed, it was customary to grant those who led gigantic exploits royal titles, including knighthood. The colonized people were given mere pittance, which were considered as gifts from the monarchy, and mystically called royalties, a dash to the royal highness. This is the beginning of the word royalties. Today, we have been several years independence, but the underpinning conceptualization of royalties persists. In the colonial years, no taxes were payable by royal fiat because, after all, the companies were operating under royal charter for royal benefit. After independence, the best we thought we could do for our people was to give those companies 10 years tax-free to mine and ship away gold, etc. in our land. Incidentally, there have been cases where Company A mines for 9 years, and rather than start paying tax soon, it backs up and sister company, Company B, buys the mine and takes on the process and continues with the process, and the tax payment or honeymoon starts again. In the depth of poverty, we fold our arms and leave this rich sector to foreigners, falsely believing that we cannot afford to intervene. But experts have pointed out that if you have a good business plan as a nation, you can raise capital by hiring experts, and once it is validated by renowned companies such as Pricewaterhouse and Deloitte and Touche, etc., the relevant monies can be raised in the global money market. The time has come when we should take our destiny into our own hands. Mr. Chairman, in the midst of plenty, no government after President Nkrumah has been able to finance infrastructure, health, education, food, and essentials of our lives without resorting to borrowing as national expenditure blows over national income. From May 1966 to date, this has been Ghana's suggestion to the IMF. I'll take you through the list so that we will know we are not talking politics. Because the problem has gone through every regime since the overthrow of Ali Nkrumah. During that period, we didn't go to the IMF, 57 to 66. May 66 to 67. 67 to 68, number 2. 68 to 69, and you know who was in charge. 69 to 70. 79 to 80, we were there again. 83 to 84, 84 to 85, 86 to 87, 87, 88, 88, 92, 95, 99, 99, 2002, 2003 to 6, 2009 to 12, 2015 to 19, 2020, 2023 to 2026. Every regime has been there. And when we talk therefore about this problem, we all are inside. Therefore, we must look at it objectively and find solutions to the perennial IMF situation. Ghana is often said to have gone to the IMF 17 times. but the IMF's own record show 18 times. That is technical calculation that they make. Distinguished ladies and gentlemen, the question is, should we fold our arms and wait inevitably to contract the 18th IMF after the 17th? This is why we are here. If not, what will we do to bail ourselves out of the perennial bailout? We go in, we bail in, and then they bail us out only for us to go back to jail. That is the problem that is facing us. Ghana was not part of the Industrial Revolution, and its current aftermath of global industries, the current ICT revolution passed us by, and its attendant robotic applications of the 21st century have not been on our lot. So the question is, what do we have, and how do we get out of this quagmire? Is our redemption close by us? We remember that when God sent Moses to lead Israel out of Egypt, Moses asked how he could carry out the gigantic mission. God asked him, what do you have? He said, I have a stick. He said, use your stick. The answer is for us to avoid the 18th IMF. Our stick is the gold, the diamonds, bauxite, manganese, lithium, oil, etc., which God has put down for us, but which we have failed or refused to manage to our advantage and dash them out to foreigners who take our resources free. The central thesis in this the project on hand is a call for a new paradigm, that is, to maximize our benefits from our natural resources, to build the new Dubai for Ghana. It is possible to rethink the fundamentals of our economic choices and rearrange our natural resource management in accordance with this aspiration. Call to negotiate all contracts. There is an imperative need to reconsider our various contracts by virtue of the right to negotiate, recognized by the United Nations Organization. The UN Resolution 3281XXX on natural resources is supportive of our stand on the control of natural resources, economic rights, and duties of states. The details are spelled out, which essentially says that every state has the right over and sovereign inalienable right to choose its economic system as well as its political, social, and cultural systems in accordance with the will of its people without outside interference, coercion, or threat in any form whatsoever. It goes on to say that the minerals in any state is to the benefit of its own people, and it has the right to regulate and exercise authority over foreign investment within its national jurisdiction, in accordance with its own laws and regulations, and in conformity with national objectives. It goes on to make it quite clear that the world is sympathetic towards owners of natural resources to be used for its own people. The details are more clearly stated in the presentation. In 1977, Libya's government nationalized the oil concessions held by Texaco and California Pacific Oil Company in the course of a larger move towards national control over natural resources. After a number of difficulties, the American company had to settle for Libya to control and manage its own resources. Distinguished ladies and gentlemen, we are sat, we are folded on our arms, and we have not been able to pursue our interests well. This is the background to the current case of Talo versus the Republic of Ghana. Indeed, the Ghana Revenue Authority argued in that particular case that it was simply applying existing laws in Ghana and the regulations, and Talo should comply. The tax that everybody pays, they said they were not going to pay because they were relying upon protectionist measures from their own country. The International Chamber of Commerce, ICC, ruled that branch profit remittances, that is BPRT, is not applicable to Talo and Ghana's operation under the current petroleum agreement. Whereas in Ghana, we said they were entitled to pay. It is a matter of public record that Talo's operational relationship with Ghana has been riddled with challenges, including a series of high-profile international arbitration disputes that cast a shadow of doubt over the existing petroleum agreement. A notable instance occurred when the Ghana Revenue Authority insisted on one point by way of $320 million. Maybe that alone will have saved it from IMF. But which Talo now took abroad to the global international level. The International Chamber of Commerce, ICC, in London, ruled in favor of Talo. Of course, they would. The London-based ICC held that Talo was not liable to pay us the $380 million, and furthermore, directed Ghana to pay costs. 1946, that is 1 million, talking in pounds sterling, 1.9 million in effect for towards Talo. Currently, we here are currently alarmed about another tax dispute in which Talo has refused to pay. The second one has now also come. They have refused to pay. And it is contesting what the GRA has assessed as tax liability based upon what they themselves, by their agreement, according to the Ghanaian position, to pay. Once again, Talo has opted for international arbitration in their country against settling our tax assessment. Then Talo comes round and says, while this is continuing, Ghana should renew their license for more years. At the moment, an MOU has been signed. I have not cited the MOU yet. Of course, MOUs are not binding in law, but we should caution that nothing by way of an agreement should be signed with Talo whilst we are still in the wilderness with them. Our people, more than God, you know my yard. And the guys say, I don't know you, your family. We have a problem with them. We are not settled it. I want it to be registered. I happen to have been personally involved in Talo from the beginning as a Minister of Energy. There's a principle in the system called first finders. Ghana were then first finders. Therefore, we have to be very careful, accommodating, enticing, in order that we will also now find oil to be among the oil-producing nations of the world. Talo can never have the same arrangement again because they were favored in the first place as first finders as against an international country. It is an agreement that will be seriously scrutinized so that now that we are first finders, we are beyond first finders, second, third, fourth, fifth finders, now known among the Committee of Nations who produce oil, we have to resit and renegotiate effectively. On 7th August 2025, very recently, Tullow reported a loss of $61 million for the first half of 2025. The situation is really tricky, and it is going to inform some of the recommendations we are going to make. A company that does not want to make profit, or rather declare profit, will never declare profit. Every expenditure will find some hole or the other. And in fact, when Tullow made this observation, I spoke to an accountant friend. He said, if they don't want to pay, after all, they own the books, and they make every expenditure of even stationery, extra, which you don't have anything to do with. Therefore, they can declare anything. And ladies and gentlemen, this is why ultimately we are going to talk about co-ownership. If you don't own part of the oil, the majority shareholder as the person on whose land or inside whose land the oil flows, then of course you are always going to be cheated. Parliamentary approval. As we speak, it is provided by our Constitution that parliamentary approval must be sought anytime there is an agreement. Let me rather paraphrase this side before we even come to the text, make things quicker for us. By this provision, one view is that before you can even touch the ground, the agreement must be formalized in Parliament. And in fact, for that matter, as the lawyers will say, promulgated, so that everybody will know that there is such an event on our soil. Is that not so? But before you can say Jack, maybe Jill, the foreigners are on the site, working, mining, taking the mineral away, whether it is lithium or whatever. And it's all because of this misconception about the word ratification used in our Constitution. Ratification is necessary and ex post facto event, because you ratify something after it's been done. Is that not so? But after it has been done for how long? 2 weeks, 1 month, 1 year. My latest inquiry was that the lithium agreement had not been approved by Parliament, or that it had not been laid there. The last time we heard about the Suya place, what was happening? They said they had an accident, some Ghanaians have been seriously wounded. It is even being said that some died, many people died, and whatever. Nobody has instituted an inquiry into this, and nobody knows for certain whether after that they've started mining again. This secrecy is painful, because we don't even know. But we have also contracted that disputes under that agreement should be sent to us, London. Now, supposing our Parliament, in the interest of Ghana, does not want to renew and refuses it later, what will happen to the work they've done there? Will they sue us for financial loss? And if they do, and they take us to their country, shall we not pay damages as they wish for them? Ladies and gentlemen, these are dangerous issues. But one thing that we know also is that under that very constitution of ours, we have a provision that we call prior approval. That is, a minister does not become a minister when the president names him until he has had or she has had prior approval in parliament. Is that our law? If so, we will recommend that a constitutional amendment must be made so that prior approval rather than ratification becomes a condition precedent to any foreigner having an interest in our minerals. And we need this as a practice. Substituting ratification with prior approval. This is the Ghana has recently discovered TB. And in this process, we will need to provide certain important securities. The fundamental principle is that the lithium belongs to Ghana. In the future, by the joint venture agreement, which is one of the alternatives being used in other places, and we shall consider some of them soon, we bring our land under which the minerals are to the table. And of course, your capital we can find from other sources. But they are also quantifiable and valuable. They can be valued. They will sit down and work the equities. And until we become owners or serious majority owners who are also in charge of the finances and the top positions in those companies, we should expect what has happened with our not getting anything from Talo to continue indefinitely. We may apply other arrangements which have been done in other places. As per present global practices, a local refinery must be established in this country Ghana before any excavation actually commences. Because if you do not do that, when, where, and how can we get employment from our teeny young people who are coming out of the technical institutes, from the universities and other educational institutions? How do we do that? For that matter, all that will generate employment for our people right here, rather than taking away the finished, the raw product, should be seriously eschewed. In the present arrangement regarding the lithium, Ghana has got 10% royalties. 10% royalties. And I've told you the beginning of royalties. I don't know which royal family you want to be. 13% direct interest, 6% participation interest, 3.06 share in the mother company. Now they say we have a company. The whole of your country, your country Ghana, the nation should come. We give them 3.06 share. All of us, 20 million people. And that one company, 3.6 share company, share in their company. I don't see how any Ghanaian can clap for this. Because in fact, it's a slap in the face. Yeah. And if you have such an insignificant share in any company, you have nothing, save the magnanimity, if any, of the owner, majority owner. Because he will declare everything. Yeah. And if for 20 years no profits are declared, your 3.06% so-called share is tantamount to nothing. These are some of the issues that we want to become national debate. For and against, whatever, in whatever form. Starting from the IEA. And a lot of things have happened like that before from here. Because when things are put in the open, better results are achieved. If they don't declare profit, we have done. And we are not interested in royalties. We are also aware of the emerging and more improved list that has been adopted by major lithium producers such as Mexico, Bolivia, and Chile. All these are what one may call best practices. And these best practices are available for anyone who will care to read and write or download information from the internet. And we cannot be taken for the ride. This part of the 21st century. The Republic of Ghana will recommend you set up a Ghana Lithium Company, GLC. The GLC should be commissioned to develop the entire value chain from raw lithium to batteries in Ghana. Today the batteries, we are told, will soon be even moving the planes. Now we know they are moving the cars. Therefore, the lithium is really God-given. We should believe that it's God-given at a time like this. And if we should not go to the 18th IMF, then it is important that every one of us should be interested. How do we deal with this lithium? With the Almighty has sent to us. Given a projected annual estimate of about $24 billion of lithium carbonate that can be generated from the Oquaye lithium deposit, the GLC, that's the Ghana Lithium Company, which we should have, can contract international companies with the necessary expertise through competitive bidding to develop and process Ghana's lithium into its final products such as batteries and others. This is the modern way of developing natural resources in smart countries. Let it not be said that we are not smart. And let me add as a Ghanaian that this is not what the Dubai people did. So, if we talk about best practices, why don't we go to Dubai and get Dubai? Or even for Ghanaians to pause and ask, or for us, we just wait, go to the next 18th IMF. I think our body adopting this model can create job opportunities for Ghanaians in the entire lithium value chain. Because it is a real extensive value chain from this to that, to that, to that, until even we use all the other side products for other economic purposes. President Kagame would not have put it more eloquently when he said, if the owners of natural resources go around begging, then you should know there is something wrong with their minds. And that is why we want that we don't go and beg again. It shouldn't happen. It just should not happen again that we can go the 18th island. Because it is perennial, it is inevitable, it is necessarily consequential if we continue with the present model. Is that not so? But we cannot just go on getting in and out. And that's why I say it is beyond any political party, it is beyond any regime. Whoever maintains the present status quo will definitely go to the 18th IMF, which we don't want to go. That is the equation before us. I present a small profile on the Ghana's Chamber of Mines and the Ghanaian counterpart. And I give this history. For the sake of quick presentation, it is a purely foreign entity. At one time, even I was thinking it's a Ghanaian company or institution. It has nothing to do with Ghana. It is purely European. It's purely foreign. And it is only foreign interests that they protect. And that being so, my recommendation is that Ghana should provide a countervailing and leveraging institution of Ghanaians to protect our national interests. We should have our counterpart chamber of mines. Because the chamber of mines is European. I have stated the details of when it was founded, when it was registered as a company, who are the owners of it, and it is 100% European institution in our land. And when we speak about gold, diamond, etc., they are our spokespeople. And we must research on this, take nothing for granted, and make sure that we have a counter-leveraging institution of Ghanaians to protect our national interests. And I ask how this should be done can be part of a national conversation. And in fact, it's going to be part of what we are going to talk about for the rest of the year and for some part of next year. How do we form this once we know that it is capable of being formed? It should be formal. It should be independent. It must be knowledgeable. It must be technocratic and with integrity to protect the Ghanaian interests. That institution is unfortunately lacking as of yesterday. Furthermore, it is time to have a serious conversation with our foreign partners and undertake a review. They must be willing to do this and embrace reform. You should know those who do not listen to the voice of modernization today live to regret the consequences of tomorrow. A number of things are happening in many other parts of Africa. There is a rebellion against poverty in the midst of ages. Before the French Revolution, a queen saw a huge protest by the people. She asked, what is happening? She was told the people were on demonstration because they had no bread to eat. The monarch, who did not know what was happening, promptly replied, if they have no bread, then give them cakes. Give them cake if there's no bread. Because to her, bread was just like cake. No wonder, in no time, the French Revolution wiped out the entire royal family. Ghana cannot afford the 18th IMF, which is inevitable if the unbridled exploitation continues. It will spell doom for all those who refuse to accept the mutational forces of history. Those who refuse to accept the mutational force of history will live to regret the consequences. We have put down also best practices in other places. The British model itself, how they did this for their own benefit. The Norwegian model, the benefits from there, and the lessons have all been listed as best practices for those who care to know. Because it appears sometimes we don't even care to know. Listen, ladies and gentlemen. Constitutional, legal, institutional, and administrative issues in the process. Constitutional, legal, and institutional issues require serious mention. In this regard, the Center for Constitutional Studies within the IEA has made recommendations to the Constitutional Reform Committee recently set up by our President. The key issue is that the Minerals Commission should be reformed. And these are some of our thoughts. Politicization must be eschewed. The Commission must be technocratic, endowed with institutional representation. This will encompass proven experts in natural resources, including oil, gas, etc., economists, lawyers, researchers, planners, environmentalists, and academics, etc. Let us be honest. If you are made a minister of lands and mineral resources tomorrow, it cannot turn you into an expert. It's a position I've occupied before. I say that will not turn you into an expert. And these matters must have institutional backup in order to advise and direct those in political authority. And you will realize that this has been one of the key issues in Singapore. And their leader had always talked about technocratic governance. These persons should be institutionally represented. For example, institution of engineers and other technical professional bodies, they will be nominated onto the commission by their own institutions and can only be removed by the members of their institutions. In other words, if you are a representation of the University of Ghana or University Teachers Association of Ghana, no president can remove you, except that those people feel you are not representing them well enough. Institutionalism must take center stage in good governance in this country. Members will serve for a fixed term of 6 years, and their tenure will not be coterminous with that of the President of Ghana. The President may only appoint 1 or 2 persons to the Commission whose tenure shall end with that President. The Commission of 9 members shall elect their own chairperson and also appoint the Chief Executive and other officers in consultation with the Public Service Commission with security of tenure guarantee. These are initial suggestions, but the underlying principle is the establishment of a technocratic and political minerals commission which shall operate with transparency and institutional independence and discipline as much as it is humanly possible. Another principle should be the practice of public inquiry. This is a powerful principle in English planning law and practice. Before a tree is pulled down, a highway is built, or any fresh step taken regarding to an existing facility, an open, frank, and transparent public inquiry is held, and views, suggestions are brought forward. I don't know when you last remember taking part in such a public inquiry procedure. Our mineral resources decisions must be no more taken behind closed doors, only for the owners, the people, to be told later. Africa Union. Ghana must take this matter to the Africa Union. If we sensitively look around, we will realize that controversies rage over our mineral rights in all our countries. First, a powerful African Minerals Commission must be instituted with technical expertise. Second, we should collectively aim at how best to renegotiate our mining leases. Third, we should provide technical expertise and advice on taxation, etc., to all our nations as a countervailing benefit. And I'm not a taxman, but I had a serious discussion with a tax expert, and he said, unless we change our ways and systems, these foreigners will continue to dupe us. He used the word dupe. And he said, it all depends, like Talo is doing now, on what you feed into the system. And it is another case of damage in, damage out. But I don't know, I don't think we want to do damage in, damage out until the 18th IMF, and then we start again. In my view, an African continental approach would be a ready think tank to be freely tapped by all honest politicians. The corrupt ones cannot feign ignorance on the best practices. We only have to ask that minister or person, have you consulted the African Union Minerals Commission? And the catch will be out of the bag. Once more, institutional establishments as a way of protecting our national interests. Finally, the controversy regarding whether foreign law or local law should apply and what country should be the geographical location for litigation should be resolved in our favor. The subject matter is exclusively in Ghana. The defendant is also permanent in Ghana. In Ghana law and also in English law, wherever the matter of which the High Court should have jurisdiction is in civil suit, the location of the subject matter and where the defendant is ordinarily resident determine which court should have jurisdiction. And every lawyer will tell you, yes, the subject matter of the dispute, where is it located? The defendant in the matter, where is he located? If the answer is Ghana, then they have cheated it for too long. Because that is the law in their own country. I have no doubt about it, and I know. And that is the law in our country. Why then should we go to their court? We should refuse. We should rebel against this. We should refuse to be bullied and take the matter up fully, legally. Because I said the law, by way of giving study of conflict of laws, favors us, and that is the position. You die 1 or 2 months for too long. Conclusion. Ladies and gentlemen, this allows me to conclude with useful information said to me some 4 days ago when I was in the process of completing my presentation. The person just sent this to me random. Didn't know how significant it would be to my purpose. Ghana, a nation that led Africa's independence, in 1957, singing freedom, and became the star of hope for the continent. But decades later, where are we? Begging, borrowing, and bowing. A Ghanaian living in Japan for over a year, noticed something strange. Though the people were polite and helpful, no one ever invited him into their home, not even for a cup of tea. The blessed and hurt finally asked the Japanese apprentice why. After a long pause, the friend replied, "We are taught Ghanaian history, not for inspiration, but as a warning." This confused the Ghanaian, who asked, "A warning? Tell me." The Ghanaian continued, the Japanese continued. "How many British rule your Gold Coast?" The Ghanaian thought, perhaps a few thousand. The Japanese nodded. "Perhaps a few thousand." And how many Ghanaians lived there? By 1957. Over 6 million, right? Then who oppressed the people? Who carried out the orders to beat and shoot them? When the colonial governor gave the command fire at December or so, who pulled the trigger? The soldiers were British, they were black. No one tell his rifle on him. You talk of colonial oppression, but the deeper chains were not on your hands. They were on your soul. The Ghanaians stood frozen, silent, ashamed. Then the police friend continued. Did the British bring millions of troops to control you? The answer, no. They ruled because your own chiefs signed treaties. Your own brothers betrayed your warriors. Yara Santiwak was left to fight alone. Nipa Napoli was betrayed. Kwame Nkrumah was overthrown with the help of his own people. You don't need foreign enemies. Your own people betray you again and again for power, for position, for personal gain. That is why we keep our distance. They don't want us to pollute them. You tell them, these people keep away from them. This is how they are. You killed your own to please them. Even today, you haven't changed. Offer some free fertilizer, a bag of rice, a piece of cloth, and your vote, your conscience, your future are all so without the second touch. Your loyalty lies not with Ghana, but with your stomach. This is the observation of a foreigner. If our people will not do the right thing, some people say the Constitution, the law, all these things, the American Constitution is seen, and so on and so forth. Our legal and constitutional arrangements, our institutional formulations must bind people in such a way that it be most inflexible for them to join us. Let us think.